What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. All right, let's get to Kohberger. Welcome in everybody that is watching this as we clip it out and we talk Brian Kohberger. We discuss the Pennsylvania grand jury now and potential alibis Kohberger may have and things the state is asking for. So first, let's just hit this Pennsylvania grand jury real quick. Just because a grand jury is called does not mean Brian Kohberger is going to get indicted on charges in connection with a missing person that was found. They went missing in June of 2022 around where his parents live. His parents could be called as witnesses for a grand jury for a million different reasons. It could be because they're looking at Brian Kohberger. It could be because they're looking at someone else that the parents may have information on. It could be that something happened in the parents' neighborhood that they could also be witnesses for something totally unrelated to him. Additionally, it sounds like reports are it's an investigative grand jury. So they're not even looking to indict anybody at this point, but just potentially get information, have them make a call, have them issue a report or certain findings. That's something a grand jury can do as well. It's less known. And again, my dad would probably be able to come on and explain it better because he's done them before, but it does not mean Brian Kohberger is going to get indicted in Pennsylvania. It also doesn't mean he's not going to get indicted. It doesn't mean he's not going to get indicted, right? We don't know is the point. I just don't want to add it to his, profile of a serial killer. That's not what I'm going to do with this information. And I wanted to make sure that people understand that and that we're not there yet. Brian Kohberger absolutely could have committed the crimes in Idaho. He absolutely could have committed the crimes in Pennsylvania that people are talking about. But we just don't know that yet. We need a lot more evidence, a lot more facts, and it just hasn't happened yet. So let's make sure we keep that in our mind as we hear everything coming out about that. But some other stuff happened. People are saying Brian Kohberger has an alibi. And why are they saying that? Well, the state has demanded that Brian Kohberger give them information about his alibi. State's request for discovery, disclosure, and alibi demand. So the state knows, and yet there's sarcasm. I hope everybody understands by now in my tweets sometimes and on my videos, there is some sarcasm. I have a little bit of sarcasm to me. So they are demanding it because they know he has an alibi. Sarcasm, right? Little star there. Please take notice that the undersigned, pursuant to Rule 16 of Idaho Criminal Rules, request discovery and inspection of the following information, evidence, and material. All books, papers, documents, photographs, tangible objects, or copies, or portions thereof, which are within the possession, custody, or control of the defendant, and which the defendant intends to introduce in evidence at trial. Number 2, all results or reports of physical or mental examinations and of scientific tests or experiments made in connection with this case or copies thereof within the possession or control of the defendant, which the defendant intends to introduce in evidence at trial, or which were prepared by a witness whom the defendant intends to call at trial when the results or reports relate to the testimony of witnesses. A list of the names and addresses of all the witnesses the defendant intends to call at trial. All summaries of or reports of any testimony that the defense intends to introduce pursuant to these rules. The summaries provided must describe the witness's opinion, the facts and data for those opinions, and the witness's qualifications. Disclosure of expert opinions regarding mental health shall also comply with the requirement IC 18207. And then this is a continuing request. So this so far is nothing more than a simple discovery request. You would think the state already has everything. Well, this is just to make sure that they aren't missing anything, that the defense doesn't have any evidence that they haven't turned over to the state yet, or that the state hasn't gotten yet. This is also letting the state know who the defense's witnesses are going to be. This is letting the state know who the defense's expert witnesses are going to be and what their expert opinion is, what data and facts and reports they may have relied on, and what reports or summaries they may have created that may come in at trial. That's all this initial discovery request is. All right, let's get to the bigger question. The undersigned further requests permission to copy and inspect said information. Evidence and materials. Okay, that's fine. Further, in all caps, the state hereby demands of the defendant notice of defense of alibi pursuant to Idaho Code 19519 and Idaho Criminal Rule 12.1. Filed May 23rd by the prosecutor. So, interesting, right? Well, let's take a look and do what lawyers do. Let's take a look at the rule that was referenced. You might not be able to read this, but that's okay. I will read it to you. This is Idaho Rule 19519, which was what was referenced. Notice of defense of alibi. At any time after arraignment, which just happened, before a magistrate, upon a complaint, and upon written demand of the prosecuting attorney, the defendant shall serve within 10 days or at such a different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defense of alibi. So, sometime after arraignment, if the state in writing demands the defense tell them, what is your alibi? Do you have an alibi defense? The defense now has 10 days to respond with that information and evidence of an alibi. So does this mean the state knows Brian Kohberger has an alibi defense? Absolutely not. They could know or they could not. But the point is they want to know, because if he doesn't tell them now, then there are arguments he can't bring it up later. Now, there are ways to get around it, especially if, something comes up and he's like, oh, I forgot about that. It actually shows I was over here. The judge usually is not going to not allow a defendant, if he has a legitimate alibi, to bring it in. But you would think at this point, if you're the defendant, you would know whether or not you have an alibi. Or if it's just, I was sleeping at my apartment and I have no witnesses, if that's your only alibi, then it's going to be a pretty short list, because you not only have to tell them about the alibi, such notice by the defendant shall state. So you don't just tell them I have an alibi. You have to state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. And then, within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial, so at some point, years apart potentially, unless the court otherwise directs, the court can always change these timelines for judicial, for judicial economy or whatever reason they may think that justice may be served. Unless the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom the prosecution intends to rely to establish the defendant's presence at the scene of the alleged offense, and any other witnesses to be relied on to rebut the testimony of the defendant's alibi witnesses. If prior to or during trial, a party learns of an additional witness whose identity, if known, should have been included in the information furnished under subsection 1 or subsection 2, the party shall promptly notify the other party or his attorney of the existence and identity of such additional witnesses. So again, this is not really a one-shot deal, but it does start the ball rolling. Upon failure of either party to comply with the requirements of this section, the court may exclude, not shall. The court has discretion to exclude the testimony of any undisclosed witness offered by such a party as to the defendant's absence from or presence at the scene of the alleged offense. This section shall not limit the right of the defendant to testify in his own behalf. For good cause shown, the court may grant an exception to any of the requirements of subsection 1. So it even states in there, that, listen, you got 10 days from May 23rd. So sometime next week, we should know if Bryan Kohberger has an alibi. But if a legitimate alibi comes in the future, the judge can totally disregard all of the requirements in subsection 1. So I think that's important for us to understand. When the state has demanded the alibi, they are starting a 10-day clock, and then they have another 10 days to respond and rebut. But it doesn't mean that Bryan Kohberger does, in fact, have some other alibi than I was sleeping in my room by myself with no witnesses. He could, but this is not confirmation of that. And if he doesn't come up with an alibi within 10 days, it doesn't mean that he can't come up with one later. And that's the really important context I wanted everybody to understand about this alibi, this demand for alibi, this discovery request, and the Pennsylvania grand jury. So that's all I had for Kohberger. And now I'm going to get to your questions about Kohberger. So people are saying, like, what about the phone pings? Sure, the state's already produced that. They've already produced the eyewitness that said they saw somebody that matches Kohberger's build, the touch DNA, the phone pings, the car, all of that's going to come in. No doubt. Mrs. E said, basically, this is nothing. It could be absolutely nothing. That's the point. It does not mean he has an alibi, but he could, of course. And again, we went over this in the Lori Vallow case. Later on in the process, she did a notice of alibi. It was not early in the process. Thank you, Joel Summer. A lot of new members, which is perfect timing. Queen B, Carlos Sue, Brandon Reed, Margarita, and Ellen. Welcome just in time, because 3 o'clock today, join us for our members only live. Jacob, this is a standard motion in Idaho. Yes, you don't have to file it. You definitely don't have to file it the day after the arraignment, but you can. Absolutely. And I probably would if I was the prosecutor. I want to know the information, especially if the defendant has not waived speedy trial. Thank you, Reba. Please, can someone explain it to us? The opinionated idiot, 2 hotties, and a hot topic equal crime overload. Please come explain it to us. I don't know what this means. I assume the opinionated idiot is somebody else in the chat. So yeah, I mean, that's the point. Is I just want to make sure everybody understands that this doesn't mean there is an alibi, and it doesn't necessarily mean that if he doesn't give one in 10 days, that it's totally out. That was the important part about Bryan Kohberger, that I wanted to come on, take a few minutes. I know the book was on Gabby Petito, but I want to take a few minutes to make sure everybody understood that. All right. You guys have been the best. Yes, Bryan Kohberger can remain silent. You guys are the best, as usual. Hit that like button if you haven't already. Subscribe to our page if you haven't already. And follow us on Instagram. It's the last day, basically, to join in for a potential giveaway. Tomorrow, we're picking 3 names, giving away a hat from the new merch site, a shirt from the new merch site, and a cup or a mug from the new merch site at Tragos Law. Give us a follow over there if you want to be entered with it for a chance to win. Linda, why would he hold back an alibi if it meant he could be released from jail? Definitely doesn't mean he's going to be released from jail, but he may not have known. Maybe he has a roommate. He thought the roommate wasn't there, and he finds out later the roommate actually was there. Maybe he finds out there was cameras inside his apartment that prove he was there that he doesn't know about now. There are ways that an alibi can come up later. Rebecca, playing devil's advocate here, isn't that making the defense tip their hand? Well, yes, that's the whole point. It's not a secret. This is not a trial by ambush. Each side gets to know what the other side's going to argue. Same thing as self-defense. You have to notify the state if you're going to claim self-defense. You can't just pop it on them at trial. And same thing with an alibi. The state has the opportunity to then rebut the alibi. Miss Lily, I think she was trying to convince him no to end his life. She still loves him even in jail. This is referencing the burn after reading letter. Some people are behind on the video, so the chat still comes through later, but glad we got to it. Conservative Corey Ann, welcome. Blessed Mommy of 4, also welcome. All right. And we've got a lot of action on Instagram over this, so I think we're going to do more giveaways over there, giveaways over here. We're going to hit 250K over here, and it's going to be a big special show, giveaways, all that stuff. I love giveaways. It's really fun. The live event later today is 3 p.m. Eastern. That's all I've got today. I love you all. Hit the like button, subscribe, share with your friends. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.